I just need it for a few minutes, just because I'm just going to start the meeting, and then the chair who's elected will take over the meeting. So I'll just do the election and then pass it off to the chair. So we need to call for nominations for the chair. So I'm just going to start the meeting and then pass it off to the elected, the chair who's elected for this year. Okay, staff is calling the meeting to order at 1:06 p.m. And we'd like to acknowledge and respect the Indigenous people within whose traditional lands we are meeting today. I'm going to call for nominations. So I'll put out the first call for nominations for the chair for the 2024 year.
You guys in the room have to make it speak up.
I nominate Julie March.
Okay, I second that.
Okay, I'll do another call for nominations. Any other call for nominations?
You want to confirm Julie would stand, right? Sorry, Laura.
Okay.
Okay, I call Sean.
Nope.
I don't
want to stand.
Okay.
Julie, you have to acknowledge if you want to stand.
Oh, I acknowledge that I want to stand.
Can you hear that, Sadie?
Yes, I hear it.
So I think now, so staff can ratify the appointment of commission. Oh.
You need to call 3 times. Sorry, Laura.
Oh, 3 times. Okay, sorry. I didn't realize I had to continue.
Yeah, no, you do the first time and the person will stand. You call for a second and the third and final time. If there's another nomination, then you have a vote. If there's no other nomination, then it would be an acclamation.
Okay. Okay, so I'll call again for nominations for the chair.
Decline.
And one more call for nominations for chair.
Oh, I just have to say it?
Well, if you want to nominate somebody, you state their name and they'll confirm if they'll stand or not.
Oh, okay, well, Julie's already been called.
Okay, so we've called 3 times for nominations. And so staff will ratify the appointment of Julie, what's your last name? March, as chair of the Area A Advisory Planning and Heritage Commission for the remainder of the 2024 year.
Right, and note by acclamation, Sadie. Appointed by acclamation. Perfect.
Thank you. Okay. All right, we're good then. So adoption of agenda.
Adoption of the agenda moved and resolved. The agenda for the February 1st, 2024 Electoral A Advisory Planning and Heritage Commission meeting be adopted as circulated.
Has everybody seen it?
Has everybody seen?
Have you seen?
Yes.
Michelle, have you? No.
Oh, yes, I did see that. Okay. And receipt of minutes. Who would have that? The January 4th, 2024 electoral.
Guys,
Go
can I
ahead.
just jump in for a second?
Yeah.
So in terms of like when you move and second something, you need, one person, maybe Gary, correct me if I'm wrong, but you need one person to put forward that motion and then have a person second it. And then you guys all have a little vote and then it's carried by majority vote.
Exactly.
That's right, Gary. Yeah.
Okay. So we need the adoption of the agenda moved.
Somebody, did we adopt the agenda?
I second it. Okay. And then the receipt of minutes.
This does not require a motion.
It does. Receipt of minutes does not require a motion. Okay. I will.
Yeah,
I will.
the minutes have, if I can, the minutes have already gone to the board. So they've been received and passed through the board from the previous meeting. If you noted errors or omissions in the minutes, you could note them now and the minutes could be amended and put to the next board meeting. I don't think that's the case here.
Okay, and who has the minutes?
They were attached to the agenda package.
Package.
So,
They're
in the email, a PDF.
Can we run through them? Is it long, Sean? Have you
I
got it
don't
there?
have them here.
Oh, okay.
And I don't think there's any errors. I don't. Okay.
I can't remember.
So then we move
Well,
on to,
we have to accept them.
no, not
Oh, we
the,
don't.
not the minutes,
Not the
John's
minutes.
saying.
Oh,
Okay. So thank you, bear with us, we're learning this. So then we move to the staff reports, which is, this is with John Drysdale, 6.1 site-specific floodplain exemption application, F2304A. The referral package dated January 9th, 2024 from planner Zachary Giamacho has been received. So somebody has to move this in second? Is that correct here?
Not quite, I guess. It is received as part of the agenda package. You don't have to move receipt. It's there. The note here is, of course, and I should ask who's in the room, but this would be where John, if he wants, could speak to his application. So, you introduce the item as it says, let John speak to his application. And then if you have any questions for the applicant, you would ask them now. Then he would sit back and then you'd have your conversation and decide, support, not support from there.
Okay,
Who is in the room?
So Brad Drysdale and John
We have-
Drysdale.
Oh,
Did you
okay.
hear that, Director Jackman?
Yep,
Brad
and
and
John.
John. Brad. Yeah.
And then who else is there? There's I've
And
heard
Gary,
Sean.
we also have Sean, Bronca, Michelle, Julie, and myself and Laura Christie, which is our other planning technician. And I've got that all down for the minutes too.
Yep. Excellent, thanks.
and shall I read out what it says here on the agenda so the other people in the room know what we're talking about? That the area that the Area A Advisory Planning Commission support or not support the site-specific floodplain exemption application to John Drysdale for the property located at 10789 Highway 3A and legally described as Lot A District, Lot 913, Kootenai District Plan 5183. And here
Yes.
we would invite John and Brad to speak if you like.
Yeah, so you're not moving that, but that's perfect, Julie, that's the topic. And you won't do, that's the business part after the presentation, the delegation, so that's perfect.
Okay.
Well, thank you very much, ladies and gentlemen, for giving us an opportunity to speak. We are applying for a floodplain exemption for a portion of a deck that was built in error at the time because we were under the impression that the deck needed to be 40 feet from the lake. However, it's 40 feet in distance as you look straight down. Now, the reason why we are applying for the application is because the property is built on a very large rock cliff. So when you look at the property, the deck is actually 56 feet or 18 meters above the 536 meter floodplain level. However, we are too close laterally, I guess, but vertically, we are quite far from the floodplain, 56 feet, in fact, above it. So we had an environmental assessment done by a doctor from Vast Enterprises in Cranbrook, in which she spoke and said there's no environmental impact or structural engineer inspect the deck, and he approved it in terms of its structure. And we also had a geotechnical engineer inspect the rock cliff and the area, and he determined that there is no way that there would be any erosion or difficulties as a result of impacting the lake itself. So we felt we could apply for a variance, looking at the rationale behind what the floodplain act was put in to protect. And we hope that with the application that due to 3 engineering reports and experts that it would satisfy the regional district's concern as to the floodplain risk. But thank you very much.
I just want to add the cost of the doctor to do the environmental study. She quoted me $9,000 for her report, which I had done. The engineer was $4,000, and the other engineer was around $2,000. So I'm looking at, to get a variance, I'm looking at close to $15,000 out of my pocket. Unbelievable. And I'm not on a floodplain, I'm on a cliff. Thank you.
Can I ask, as an ignorant commissioner?
Sorry, Sadie, did you need to say something?
Nope, all good.
Okay.
I just wanted to ask, as an ignorant commissioner.
Excuse me?
I just wanted to ask, as I'm an ignorant commissioner, this is all new for me, why anybody's asking you to get this variance? Has the district come to you and said, you built erroneously, you got to take it down, or you're going to pay a fine?
Correct.
Okay.
They've asked us to apply for the variance because what we misunderstood was from the floodplain level, which is 536 meters above sea level. That's, they're saying, is the highest that Kootenay Lake they plan to have at a flood level. Then you have to be 40 feet, or I think it's 15 meters set back. And you see, since we're above, we thought the setback could be diagonal, but it has to be in a horizontal fashion.
Or horizontal.
But we're hoping for the variance application because even though we are within the 40 feet or 15 meters laterally, we're in fact 50 feet above the lake. So there's no way we believe it's possible for the lake to rise at that level. I mean, it's way beyond the level in which they've stated the floodplain exists. So for our deck to be infringed by water, the water would be going over the dams and Nelson would be underwater.
But it still costs me money to do it.
Yeah.
I can add a little detail too, just on the RDCK process, if that's helpful.
Sure, that would be great.
Yeah, so in terms of these, perfect. So in terms of any of these applications that are required by the RDCK, there was 2 that the applicant brought up. The first is the environmentally sensitive development permit area.
Thank you.
That permit is only triggered if you
Thank
want
you.
to do any works within 15 meters of the natural boundary of Kootenay Lake. So if they had been able to build the deck outside of that, that application wouldn't be required. And actually, it wasn't required in this case because they had that report from, I guess, the registered biologist, I'm imagining, who said that it didn't have any negative impact. So they didn't have to do that application. But this application, the floodplain exemption, that's triggered anytime someone wants to do this kind of development within 15 meters of Kootenay Lake or below the specified flood construction level. So if, unfortunately, if they had been able to ahead of time not go into that setback, it wouldn't have been an issue and they wouldn't have had to make this application. But yeah, unfortunately that didn't happen. And so here they are.
And if I could just add up to that, we've owned this property for 55 years, and it's always been a dream of my dad to build out at the lake. So we aren't developers, people that are looking to flip. We are definitely an intergenerational family that's looking to build a property there. I just want to make that clear.
Kootenai Lake is one of the most beautiful lakes in the world. And I say that as I've traveled quite a bit. It's a beautiful lake. And I want to spend my last years on the deck.
Could I add a little context? And I'm not part of your commission and I don't vote on anything and I'm here as a support or a resource. Just to add a little bit to maybe what Sadie indicated, the floodplain setback is a provincial number. They created those numbers. The 50 feet or 15 meters applies to all of Kootenai Lake, regardless of whether you're on a delta or alluvial fan or whether you're on the cliff. It's just a number that the province threw the dart and says, here's a number. Interestingly, on Crawford Creek, it's 100 feet, 30 meters. That's because it meanders. So there's numbers that have just come out from the province that there's a process to say, okay, here's where you are is at a risk. The environmental development permit area, that is more unique. It's not required by the province. When it came to me years ago, as should we in tandem to looking at the flood risk in that 50 foot, also look at the potential harm to the riparian area, the most productive piece of land that helps feed nutrients into the lake. Should we be paying attention to that? Because we've seen a lot of people kind of strip the front of the lake clean. So I agreed to the same setback, 50 feet or 15 meters. Area D said, Andy Shadrack in the day, let's go 100 feet. Area E said, let's go 50 feet. And Area F down West Arm towards Nelson said, no, nothing. So we're quite inconsistent on that. That is on our DCK, and that is in the interest of the long-term slow degradation of the lakefront. A big conversation is being held right now about whether that 15 meters may expand to 30. I have a lot of concerns about equity. You, John, or Brad, as next generation, should not be treated any differently from some of those big houses on the West Arm. So one of the numbers, one of the triggers is the province. The other trigger is your local government. They happen to be the same number. And as Sadie pointed out, expensive as it is, you've done the reports in the case of floodplain to show the obvious. You're not going to get flooded. Kind of like my house. You know where I live, John. By the time I'm flooded, the whole Kootenays is in big trouble. Same for you. So the numbers come from different sources, and this is more for the planning committee. We have these provincial requirements to trigger investigations, and then we have layered on that some environmental protections that I've suggested we could talk about in more depth at future meetings with staff's guidance.
Thank you for contextualizing that, Gary. I think that's helpful for all of us. Yeah.
So this is Ian, I'm just a member of the public.
Mr. Jones, let's start with that.
So it sounds the crux of this sounds to, well, it sounds like that. So there's agreement on horizontal setback.
Sorry, can I just interject? Who's speaking right now?
This is Ian. I'm on the just a member of the public.
Okay, so this is painful. No, please hold on for a second. This is painful, and we have a new chair to the process. We follow the Local Government Act, like it or not, quite a bit of the time. That's why I'm here in Vancouver or Richmond right now. We're having discussions with the province about some of the pain that the Local Government Act imposes on you guys who live here, my neighbors. Our procedures bylaw necessarily says that our commissions and committees, and that's what this is, will follow the procedures of our board. So the public, this may not sound polite at all, the public doesn't ask questions of the applicant or of the process or any of the committee right now. This is John Drysdale's time. He can respond to questions from the committee, and when the committee is finished with questions, the commission, then he would step back. Then the commission can have their discussion and come up with their recommendation. In my mind, there should be two recommendations, but come up with their recommendation to the board. And so I'll see it as a board member, so I'm not voting on any of this here. And then after that, there's public time in item 7 on the agenda. So I would ask you, even though it sounds painful, to just please hold your question that you will put through this commission chair after this item has been dealt with. And if you find that answer is not satisfactory, as I say, every month, like in the Main Street, call me, phone me, sit down for a cup of coffee. I'll talk more extensively. But right now, this is John Drysdale's time and the commission's time. So sorry, Chair Julie, back to
Thank
you.
you, Gary.
That's fine.
Yeah, because we're in a learning process here, so thank you very much. You know, we appreciate figuring out the process. So at this point, we're asking John and Brad if they have anything to add. Is that correct?
That's a normal process, yes.
Yeah, I think.
And then,
Any questions?
okay, and then the commission would have an opportunity to ask questions and then we vote on it. Is that correct?
You would ask questions of the applicant, then you would ask metaphorically for the applicant to step back, and then you have your deliberation over you think of the merits of granting. And in my view, there's two relaxations here: the environmental development permit area, and then the floodplain setback. And to me, they should both be captured in the recommendation. Yeah, and that's not a back forth with John and his son. That would just be your discussion. And as you roll through more and more of these, and some of them are very complex and not as straightforward as this may appear. And so that's why you have that separation, and when you have the question period and then when you just go into your own conversation.
Excellent. Thank you, Gary. Okay, so Brad and John, nothing else to add?
No, I'm not sure. You have to answer.
So anybody on the commission have any questions? John?
I don't have any questions. I just want you to be sure. I've seen your reports from VAST, from SNT, and from your qualified environmental professional. We've been forwarded all the photographs that you've provided, and that's all I want to. I just want to reassure you that we've reviewed all the information that you did provide. Okay.
No questions, but thank you to Sean, acknowledging that we've all reviewed that. Michelle, yes, we've all had a look. Okay, so at this point, we would vote, is that correct?
We have a
Well,
discussion. Oh, sorry, Stas.
You could have discussion, or you could move a recommendation and have discussion more limited. You can have a broad discussion and hold off moving the recommendation, or if one of the members wants to move the recommendation and is seconded, then you would have the discussion around that specific recommendation.
So I guess we need to determine if we want further discussion.
Can I just raise some points? Can I go over the conclusions of the studies from VAST Engineering? And they're located in Cranbrook, is that correct?
That's correct.
Yeah. So there aren't a lot of engineers, geotechnical scientists available to this area. We have to go to great distances to Nelson, to Cranbrook. I've even been told in some cases you have to go to Kamloops and Revelstoke to get these people to determine the parameters of what is requested by RDCK to satisfy our property needs. So the conclusions of SNT, for everyone to know, is that the flood hazard at the building deck associated with Kootenai Lake was found to be very low to non-existent. There is not much of a flood hazard. And that agrees with what Brad said. They're about 15 meters above the water level, okay? Second point is the cliff face fronting the deck shows signs of weakness from spalling rock slabs. So the rock face can fall away into the water. However, this hazard at the building deck foundation due to wave erosion is considered to be also very low to non-existent. The study has found that the deck may be used safely for the intended use as required by Section 56. So they are saying that this is a safe deck. And reviewing the photographs, I see the structural materials that you use, the large steel I-beams. I see that the Schedule CB has been signed off on. So you've done a lot of work, and I appreciate the expense that you went to. I understand how much engineering reports are. I think you've satisfied everything that the RDCK has asked you to look into. I don't think there's anything further that you can do. I think that concludes the remarks that I want to make regarding this. I think you've done your due diligence.
Sean just said everything. Yeah, much more eloquent than I was. So thank
I
you.
was just reading.
Yeah, no, that's great. Thank you.
And I have a question for Gary at this point. You said that you thought there should be 2 areas considered. What would those be again?
Well, I would say that the material presented by the applicant reassures, provides it's safe for its intended use in terms of the floodplain hazard bylaw, and it also provides assurance that just to capture the fact that under the environmental development permit area, even though the formal application didn't go in, that our record or our resolution, your recommendation notes that it's also a very low impact or minimal impact, I forget what the words were, on the 15-meter riparian setback area. Just to capture those words somehow. And I don't know, Sadie, if I haven't tried to use chat here, but it might be a way to
No
capture that.
worries.
If-
I hear what you're saying. I think that the commission would have 2 options. So they could note that, as it was stated in the referral package, that the environmentally sensitive development permit application is not required because the qualified environmental professional has determined that the proposed development is outside of the riparian assessment area. And they could just say kind of that they agree with that. And I could note that, or they could make a formal motion using basically the same language that I've drafted in the agenda. Does that
Your
make
approach might be best, Sadie, because we only need the one hard motion to go to the board on
Mhm.
right now, because the other application exists. So your approach is good, but you can't say that the development is outside of the environmental protection area. You can say that it doesn't have a detrimental impact on
Yeah.
the environmental on the SPIA, the sensitive SPIA, SPEA, that it has a minimal
Streamside
impact.
protection and
Streamside
enhancement area.
protection enhancement area. Wow. I have too many meetings in a row down here. Yeah, that acronym. But I think, yeah, you're correct. If the report from the commission says that you've noted that's covered off, and then the recommendation standalone about the, just as worded in the agenda, standalone about the flood hazard is not a problem.
Okay. So we, at this point, we agreed no more discussion, and then do we need to use that specific language, the SSFEA, the site-specific floodplain exemption application? We've agreed that there isn't a risk, that there are, I don't know if you want to help us with the language again there, Gary or Sean. And somebody basically moves that, and we vote on it. Is that how that works?
Yeah, you can move the staff wording and just say support.
And
or
we can
not
just say,
support. Just use
okay,
that.
that's what's highlighted here. Okay, so we can say that the Area A Advisory Planning Commission supports the site-specific floodplain exemption application to John Drysdale for the property located 10789 Highway 38 and legally described as Lot A, District Lot 913 Cooney, District Plan 5183. Then Carrie?
I move to second that.
Yeah, and somebody has to second it. That's it.
I second
Do
it.
you
Now
second
we
it? And that's it?
vote on it.
Oh,
Then you can have further discussion. You'd call for further discussion. And if hearing none, you can call for a vote.
Oh, I see. Okay. Do we need further discussion?
I just want to clarify that it does not affect the riparian area. There is a face of a cliff there. They are saying that cliff is stable. It's not going to fall into the lake over time. It's a safe structure. He has had the property surveyed. We didn't even talk about that. He knows where his property lines are. There's no encroachment issues. I think That's all I want to add.
Due diligence has been done.
Yes. Agreed, agreed. Okay.
And Chair Sadie will capture that in the minutes, that the commission notes that there's no significant or measurable impact on the environment.
Okay.
She'll capture
No.
that, separate from the motion, she'll capture that.
And so no further discussion needed and we can vote on it?
Yes.
Where does it come in?
Oh, yeah.
Not right yet.
That would be after.
That would be after we vote.
Yeah.
Public time.
Call the vote.
So now I call the vote. All those in favor?
I'm in favor of the exemption.
In favor of the exemption.
In favor of the exemption?
In favor of the exemption.
Thank you. Thank you, thank you, thank you.
Did you get that, Sadie?
Enjoy the most
Okay.
expensive debt
I
in the
did,
world.
yes.
Have a nice.
So now,
Just one quick clarifying note. Or sorry, Gary, go ahead.
no, go ahead.
I
Sadie.
just wanted to say, just to clarify to the applicant, because it can be a bit confusing. This is an advisory group, so they're just providing advice to the regional board, who ultimately retains the power to make the decision on this application. So it's
Right.
not approved yet. It still has to go before the board.
Right,
It was just
understood.
some random guy who chairs the rural committee. They picked me again, and then it goes to the board. And would this make the agenda for February? Is it too tight?
I'm not sure. I'd have to check in with Zach.
But it's retroactive, so it won't have any impact if the board is aligned with this commission recommendation.
Okay, thank you.
Okay, John and Brad, can be dismissed if you like, unless you want to stay, but you're welcome to stay, but otherwise you.
Would you like to stay?
Well, stay, sure, till your meeting is over and then it goes over.
Okay.
Thank you.
Okay, well, thank you.
Yeah.
Okay, great. And then at this point, when I ask, does the public have anything else to say?
We'll do the bylaw amendment.
Okay,
Oh.
No,
sorry.
sorry, the bylaw amendment was removed. The applicant was revising their application, so it's straight on to public time.
Okay.
That other item will come back to you perhaps in a month. But yeah, I'm working on the amended agenda. Public time is next.
okay. Public time, any questions? Comments?
Just a curiosity about horizontal versus vertical.
And then.
Did-
Can we just announce the next meeting and then?
Well, no, sorry. I think he had a question about what's the difference between horizontal and vertical? Yeah, I could speak to it if you want.
Yeah,
Okay.
yeah, I'd love to hear your perspective on that. Yes, thank you.
Okay, so, and I've worked, because I'm one of those engineering consultants, who, not a biologist, but work on some of the stuff sometimes as well. It is a blunt instrument, 50 feet and 100 feet. They're blunt, round numbers that just extend from a line that moves. So it's 50 feet or 15 meters is what the province said, and it's horizontal because they like to map everything. We love to map everything horizontally, but if you survey it like I have, there's a combined scale factor because the world isn't round. All of that aside, it is a blunt number applied horizontally from the natural boundary, and the natural boundary moves naturally. That if weeds and trees and soil develop out further towards the water, that boundary moves and the 50-foot moves with it. That's called the process of accretion. And we're seeing accretion because of the numerous years that we've controlled and capped off the really peak floods that used to get through the Kootenai River because of the Libby Dam. So it's a horizontal number. To me, someone threw a dart, 50 feet, 100 feet, depending on the creek. And it's a number that actually moves with the definition of natural boundary. And a little bit further, a lot of people, when they get into this kind of jam and say, this is where we actually want our house, the first thing they'll do is not invest, and I feel the pain, $15,000. They could have invested that money in the surveyor and seen if the natural boundary by current survey standards, it's a civil law that governs this, and through the Surveyor General of British Columbia, they could have maybe made the case to move that natural boundary further towards the water, and that gives more land that's available for development. But it's horizontal number and it's a blunt instrument, and not much more I can say about that because we deal with blunt instruments all the time. We're dealing right now, we've been talking about 4 acts, all approved last fall, that to me seem pretty blunt, but they affect our planning staff big time. So that's what.
Thanks, Morris. Yep, that was really is it horizontal or vertical? So you answered it, and then more. So appreciate it. Thanks.
Okay. Well, I have a question here, and thank you everybody for bearing with me in this new position. I will get more important as we go. So now we've got the next meeting. Like, we're at this point with public time. There's the discussion on the variance, but is this the time we also ask if anybody else has anything to talk about?
You just have to make a call out because if people were on the WebEx,
Right.
So you can just make a general call out.
And that would include us as the commission? Like if anybody, how does that work? Like if somebody on the
No.
commission?
If I might, the time to have done that would be when you set the agenda. And so it would then be a late item, because some people do scan our agendas, and if there's something that they're quite interested in, they have the right to hear your conversation. You are a statutory commission. You're in the Local Government Act, that you have a conduit to have a direct conversation to the regional board. And because of that position, people should be able to see in advance the topics you're going to cover in each of these formal meetings. So if you wanted to add a topic as a late item, then there's 2 or 3 tests for that. Is it an emergent item that could not have been foreseen prior to setting the agenda and publishing it for anyone who wants to join in and listen to this meeting? And if it's not urgent or emergent, then you should really set it like we would as directors, a notice of motion for a future agenda item, so that everyone else in the community can see what you guys are going to be talking about, as opposed to just sort of going ad hoc and say, well, we got some time, let's start talking about how the world is going. So it should have been either a late item at the top of the meeting with reason, or absolutely you can feed information in for what's a good topic for next conversation.
You said there's 3 different things: emergent, future.
Sorry, yeah, I'm trying to get the right word. It should be an emergent or an urgent issue, like something that's new, that there's no way you could have told about it, but it's time sensitive. I guess that words together. It's a new item that you didn't know about, and it's time sensitive, or at the pleasure of the commission, like the board, a 2/3 vote, we can say we're going to talk about it anyway. But we really, really try not to do that, because then the public has had no opportunity for the heads up that maybe they wanted to listen to this conversation. You guys might talk about something next to get somebody in Area A way down in Windle or wherever, Surdar, saying, wow, that matters to us. I'm going to join this commission, right? They have no idea what you're talking about otherwise. So the topics should be published in advance whenever possible.
So maybe I'll just go over this just so I'm clear. So when we take the adoption of the agenda, I can ask, is there any emergent or urgent new agenda items to add? I would ask if that's the time we would want to add something. And otherwise, if not, and we want to move it to the next agenda, to the next meeting, when would we do that, or how do we add something to the next meeting?
I tend to do that right now. You're discussing the next meeting. So when you're discussing the next meeting, you might say, well, this would be a good agenda item for, it's February now, it's the 1st for March, right?
Right, for March 7th. Okay, so now would be the time, but I just want to clarify, so in the future, I do this correctly. When we're adopting it, I can ask, is there anything urgent to add to the agenda today? And otherwise, we can forego it till later in the meeting and add it to for the next meeting. Correct?
that should work. I don't know, Sadie or Laura, if that's
Yeah.
it's.
I might just add one point, and that only thing is that typically the matters that you consider are just referred by the board or the director. So there can be items that come up in the community. It would be possibly good to maybe even speak with Director Jackman first, who's probably going to be present at a lot of these meetings, but just to make sure that it falls within the purview of your commission and that it's something that he is interested in having you guys speak about. Gary, does that make sense to you just in terms of how the bylaw is written?
Yes, and I didn't want to sound too heavy-handed. So if ideas come up, you could probably expect I might weigh in for 2 or 3 reasons. One, is it going sideways too far from the purpose of the commission? Also, even from the meetings we're having today, we're discussing a lot of stuff around land use amendments, legal advice from guys who are 30 years experience talking about the impacts of Bill 44, Bill 46, and the like. And it might make sense to say, okay, this is a really good topic and it'd be good for the commission to understand it, but not next month, because our staff will be far better prepared if we want to include it as a topic for you guys to raise your level of understanding. Maybe it should be in 2 months. So I'm not averse to ideas coming up. And I didn't want to sound too heavy-handed, but sometimes it doesn't make sense to talk about some things until, like these bills, we have no regulations yet. I could pull my notes. I have 10 pages of notes. You can't see them, but Sadie can see them. I have pages and pages of notes. And the one guy said so many pages of legislation, so many pages of draft regulation, another 70, 80 pages of interpretation around the intent of the legislation. I thought, well, shit, I'm not going to read that 140 or 50 pages until this weekend, and maybe. So pulling a topic out of the air, it's good to go back and forth a little bit, make sure it makes sense to try and address it with full information.
Okay, but to clarify it, if we have new items to add to the agenda, we first look at when we adopt the agenda if there's anything urgent. And if not, then we leave it into the end, make the next agenda, and then that can come up and we can either determine whether it would be for the following meeting or perhaps one in the future. But just so everybody's clear about how we bring new items to the agenda.
Yeah, I think that's about as close as we can get to the intent of the bylaw. Got a little skirting around the edges a bit, but yeah. If Sadie's smiling, I hope that's good enough.
So if I have an idea for an agenda item, I could say it right now and you could say whether you need to think about it or whether we can put it on there, or do I email you later? How does that work?
Well, we're sort of testing the waters, and I'm curious what kind of items you're thinking of, and maybe Sadie would have a better answer than I would. What are you thinking for the next
I'll
meeting?
tell you what it is. My question, or what I would like to have explained, is this 30% by 2030, given that it's about preserving 30% of land, and either through land conservation or land covenants. How does that apply to our area? I've heard that there are some blocks of land that are already, I don't know about this area in particular, that are, I don't know if they're flagged or just discussed as potentials for conservation. What does it look like in our area? And how does that, who makes the decision about conservation or covenants?
So that's the parkland, which is Crown and private. And Sadie, maybe you should give some thoughts on it. Is that something that would drop onto an agenda? It is not something we're going to have a lot of control on. It'd be voluntary covenants for private land, or we negotiate deals like we did when we acquired the 28 parcels at Crawford Bay. We negotiated funding based on conservation. The 800,000 we got through Columbia Basin Trust. There's restrictions or expectations on that funding. So it's not something you would be asked to look at specifically, I guess, as I say in the short term. But I don't know, Sadie, can you see where it would apply directly?
Yeah, I mean that would be my question, is just like, would it fall within the scope of something that the board would be considering making decisions Because even if it's like a super interesting topic, if it's not something that the board would be considering, then I'm not sure it'd be a good use of like public funds to have us holding this meeting when it's maybe more appropriate for a private conversation or another group. But maybe the way to look at it is to, if you could send over like a little bit of background information and maybe how you think it relates to like the local government context. And then we can kind of have a conversation with Gary internally and see, and then kind of just follow up.
And I've
Yeah.
asked to have an Area A Regional Parks Commission formed. Hasn't happened. It doesn't fall properly under Rec 9. We actually had to strip the part out of Rec 9 because Rec 9 isn't all of Area A. The commission hasn't happened. They say, well, what about areas B and C? Would we jointly look at stuff? That's been a few years of frustration on my part waiting for that to happen. So I guess my inclination, that would have been the place to hold these conversations. It would be. Short of that, I can just call an ad hoc meeting because I really am chomping at the bit to hear what you guys want to do with the parkland we're holding now. And if you want to learn about some of the green space, the waterfront green planning stuff and the programs where you can get legal fees paid to place a covenant for environmental protection on your private property that will hold, be in place for the future landowners, that kind of stuff. There's lots of information there. So it might end up being an ad hoc community meeting. That'd be best, that people could just talk to me straight up without the rules. That'd be a more productive conversation probably as a community town hall meeting.
Okay, thank you.
And we could ask, if we wanted, we ask Brittany to sit in too, because it falls on them. It's shared interest in parkland and conservation between provincial and local.
So what you were just saying, Gary, is it could be more pertinent to talk about the Crawford Bay Park and what's going on.
Use Crawford Bay Park as a lens to frame how big this conversation is.
Okay.
Because some people want to develop, some don't. But then we can start leading into talking about, there's a lot of opportunity. I've been able to go to a lot of courses and take some training on opportunities for people to place, to identify conservation areas on their own land. And that actually gets you around the conversation we had with John today, with John Drysdale, is because it's recognized in advance. I tried to create a build line with a previous general manager of development services that would have addressed this around the entire lake, really zeroed in on these areas and predetermined some of this. I didn't get any traction with that. It doesn't yours either. So I'm not holding my breath on it, but it'd be a better town hall meeting, I think, because this isn't quite suited for that conversation. And it's not a very broad group. I mean, you guys are all keen, interested, intelligent individuals, but you're excluding most of the community from a conversation that they might really be interested in.
Yeah. Okay, thank you.
I have a topic that I'd like to present for the next meeting, if you think it falls within those guidelines, is the forestry invasive species spraying program that's been proposed. Did you look into that at all, Gary?
I have started. I am here meeting with UBCM reps and staff, talking to Bar Sahoda in particular about some of these things. I didn't talk to them about spraying, but we have staff province-wide who work for us on these big picture issues. I haven't done my search on the website to show you. I've got half a dozen people that are looking for a response. Public input deadline was yesterday, I think. That doesn't matter. But that's a big topic that, again, I don't think would normally fall into this. It's another realm entirely. That's the 5-year plans by, you get them from Fortis, get them from BC Hydro City, and even logging companies, harvesting licensees, they use herbicides to suppress deciduous growth. We're having more fruitful conversations about allowing the deciduous growth in mixed forest to provide us some fire resiliency. But that's far beyond the scope of this group.
Okay, thank you again for that. So that looks like we outside of this, we might want to be looking at a town hall meeting for some of these. I have one other question, and that's with the OCP. Just if you could just give us a brief explanation on how new bylaws come in. Like, is it up to all of the constituents to constantly be looking at the website for updates on bylaws? And how is the public notified when things change?
It's a huge
Would-
process. I'll let Gary.
So we had this morning, I'm just flipping back on my February 1st, page 1, 2. Again, we're kind of stretching things a little bit. So we had an interesting planner lawyer, and this wasn't in camera or anything. This is just talking to 100 of us in the room that said he had three main big ideas or bullets that the province is going to require a reinvigoration of the official community plan process. That the assumption that we'd have the resources and update them every 5 years isn't going to be an assumption anymore. We are going to do that. We expect by June, we're going to have you're going to do this. You're going to have a certain level of consultation every 5 years. Within that consultation period, you're going to develop a plan with a 20-year planning horizon, and you're going to include all of your housing expectations for a 20-year horizon. So I got up and spoke to 2 or 3 other pieces of legislation that overlap. We see a shift in short-term rentals will impact the ENF by virtue of Nelson's population. Probably won't affect Area A. If you require short-term rentals in certain municipalities to shut down, they will show up in the rural area adjacent, and that'll take away long-term rentals. And that takes away the housing stock. We're supposed to project how we're going to meet targets to provide that housing stock. So this legislation is tied, and it is a big thing. But that's one, reinvigorating the OCPs. The second one, he phrased it as dialing back public hearings. This has caused a lot of angst. The province will restrict opportunity for the public to be heard and talk about the impacts of redevelopment and zoning changes on their neighbors. And I've got a whole page on each of these. This is Cole's notes. And then who pays for the cost of growth? So there's development cost charge model that municipalities use. And now there's the newer model, amenities cost charges. Can you include raking off money for future development of fire halls or playgrounds or water systems or sewage or whatever? It's pretty complex. It seems they're going to copy Ontario. That's my take on it. So if I want to learn about it, aside from reading these few hundred pages, I can start looking at bulletins from Ontario. And these are changes the province is indicating. They passed the legislation. The acts have received royal assent in November 8th. The regulation that spells the details out isn't drafted and not presented to us yet. But the expectation is the timelines trigger June this year. So this is a big uncertain question, and to try and speak to and bring you guys up to speed, my head's spinning with this stuff. And a lot of it is spun around housing. Now we don't have transportation hubs, so there's very specific stuff that we don't have to worry about right now. But there's so much stuff we do have to worry about. So we have a planning workshop for rural directors. I need to sit with Nelson. I see the emails back and forth about how we're going to, 11 of us rural directors, begin to grasp how much is in front of us and what staff can handle and what they can't handle. And the province is holding a carrot out. And Sadie, I don't know what the dollar amount is. It's like $180,000 or something. If you look at the amount of work to do community consultation over 11 electoral areas with dozens and dozens of clusters of people who want their distinct voice heard, that's not going to do it. And the timeline would almost force us to use consultants, and they can just boost their price. I'd rather have our staff who understand our neighborhoods work through it in a more gentle process because they're already listening to you. They know who you are, instead of being pushed into a box and saying, do all this stuff by a certain date. And by the way, ABC Consulting, they'll do it for 100,000 step 1, 100,000 step 2, 100,000 step 3. And, oh, you ran out of money? We don't care. It's law. So the OCP review is highly topical. It's been a big part of what I've been talking about since Tuesday noon here. I'm not missing much right now. It's a finance thing that probably I'm better on budgets than most of my colleagues. I'm going to brag. But I do have to get back to the other conversation shortly. So these are tough ones. And Sadie, I don't know, are you going to have everything, your planning group going to have everything figured out by June 2024 here?
I'm so hopeful.
Oh, there you go. Geez, I'm not going to worry about it anymore.
Well, and maybe I'll just to, thank you for that, Gary. Maybe just to ask one more question around that, again, just around constituents information. So with that coming up, how do people access that information? Is it something that you're forthcoming with, that we're being presented our community? Hey, listen, this is happening today. Or are we as constituents expected individually to be paying attention all the time to what's going on? Just so if you could clarify that, that would be excellent.
I can't expect you to follow all this stuff. It is tough. I'm actually paid to be here, right? And you're not.
Yeah.
Starting
Well,
point. You're not earning other money because you're here as a volunteer. And it is tough, and our staff is paid. But I don't know, Sadie, do we have anything we can roll out? Yeah.
Well, I don't have anything right now, but I can tell you generally regarding these processes, like with the update of an OCP. For instance, electoral area I is going through their OCP review at this time, and the APHC specifically has been super involved in reviewing that document. And the public is given lots of opportunity for notification that this is happening. So there's been mail outs in Area I to actually every resident in that area got a mail out to notify them about a public meeting that they could attend for the draft OCP policies. In addition, we put everything on the website. We put notices in the newspaper. We really do our best to provide that information and be proactive with the community. There's even like entire email inboxes. A planner gets completely dedicated to this. There's always someone, like every day you can call them if you have questions. So it's not something that happens without the community. The community is very involved throughout the whole process.
But we haven't triggered our community yet. And I'm concerned we're going to have hyper compressed process. Area I and Director Davidoff, they started before COVID. They were interrupted by COVID, but they've had a few years. Area D's had an extended sort of planning 101 process. I'm worried it's going to be super compressed by provincial, just their requirements, their timeline. We did ask this lawyer planner dude if he's aware of any penalties for not meeting the provincial targets and dates, and his answer was none indicated so far, is what I wrote down in my notes here. So it may not look the same for this next round, and that's why we're having a planning workshop to talk about our capacity, what projects we need to focus on now. And when's the planning workshop? Is it the 20-something?
I think it's the 21st.
The 21st, isn't it?
I think so.
So Monday, I will sit with our head planner and a consultant, because again, we just have capacity to talk about what we're going to be able to handle in terms of, in theory, staff capacity, what we understand so far. Once we do the workshop, because we just did 2 others, that would be maybe be the time. I guess, Bronco, were you asking? Maybe after that workshop on February 21st, we will see a report to board about what material we were given to consider, not to make decisions on or deliberate, just to understand and learn. You would see that material. I mean, that's what I moved in the last 2 workshops, is that everybody sees what the board members or the rural committee members see, and then you'll see a synopsis of what we expect. So I would hope you would see that then for the March board. There would be time from February 21st to get, I would hope, to the March board as a synopsis. And that's when's March board is the 21st.
Okay, well, thank you, Gary, because that gives us a little bit more clarity. And, thank you for bringing up the concern about the compressed timeline, because I think as community members, that's definitely a concern for us as well. And so we appreciate that.
And we are going a little sideways from agenda setting, but I think this is productive. Sadie hasn't ended the meeting yet, so I guess we're good. And the chair hasn't ended the meeting yet, Julie, so I guess we're good.
Yeah, well, I think this is
I do have
important stuff.
one. I just have a quick question on process. Does Boswell Hall still work for our next meeting? And if so, I'll book that unless you guys want to come back to the Gray Creek Hall.
Well, Great Creek is great for us. Where do you live? There's 3 of us from Great Creek. I know Gary's in Boswell. Are you in Boswell?
Yeah, the connection's
The
great.
connection here is great. The wood stove's awesome.
Awesome. Yeah.
Gas stove.
It's
Let's
totally
go.
up to you guys.
Let's go.
Don't worry where I am because I'm not in Boswell. I'm not in Boswell now. That morning I'll be in Creston from 9 till noon, but I can absolutely make it back to Grey Creek. I have Crescent Valley Services Committee, so don't worry about that.
Okay, and Sean seems good with that. right?
That's going to be March 7th.
7?
Yeah.
So I can book the hall for March 7th.
Excellent.
Can we make that topic
Thanks,
for
Michelle.
that before we adjourn?
Yeah, 100%. Okay, and so Sean?
Just another topic I'd like to get more clarity on, Gary, and I don't know where we should add this, whether it be to a meeting or to a town hall or just a discussion between us. But looking at the club from 2013, every zoning category has objectives. And in particular, there's some that are of interest to me. For instance, in the agricultural land reserve, one of the objectives is to promote the removal of lands. And I know there's some exemptions to minimum lot sizes and stuff like that. And I'm just wondering if you could bring us up to speed on the process if you want to have a property removed from the ALR. And I think how this ties in is because we're going to get future applicants with variances that being in the ALR may affect whether or not they would be granted that. And then a second topic, I'll just throw it out there so you can add to it, is the relaxing of secondary dwellings on people's properties. I heard that that's going to be relaxed maybe as early as, I think, May of 2024, so just within the next couple of months. So those are 2 things that are of interest to me.
So Sadie, you'd be better one to kind of figure when you could wrap that together. In 2013, the Agricultural Land Reserve Act was quite different than it is today. There's been numerous amendments. We've people who know what they're doing have tried to keep up with the technical language changes, housekeeping changes. We've also tried to keep up with the intent. We've never been up to date entirely because they've changed every couple of years. The entire commission changed. At least they've been stable for a few years. I've met and both the chair and CEO, the president, whatever the commission, a few times. But that would be a good learning piece, and maybe that could be folded if there was time together with what else we think might happen around. To me, that's another concern where the town of Creston said, "Well, they can only increase affordable housing supply so much, and they can only increase housing supply so much by their expectations, because big developers aren't coming in there to build 100-unit apartments anymore or 50-unit. They're just not. They make so much more money in Kelowna. They are not coming to Creston. So it's the mom and pop. They've enabled now the carriage houses and legal suites in Creston. And now the mom and pops are saying, well, we want this additional house around Creston, close, maybe even bicycle into town, and it's mostly LR. So do we need to respond to that? And my short answer is yes. Have we been more restrictive than we need to be to still promote viable agriculture without the cost of the land escalating because the housing footprint being worth so much more than the revenues that you could see return from farming? So Sadie, is that a good learning topic? It is very much going to come to this group.
Yeah. I mean, I think I took like 3 things out of that, and maybe you guys can help clarify. The first one was on exclusions, and I don't know if that word was chosen deliberately, but if you guys are familiar with The ALR or ALC's regulations. In some places, individual landowners can apply to have their land excluded from the ALR if they think it's not appropriate. But a board policy in, I think it was 2020, for the RDCK basically said we're not going to process individual exclusion applications. So that can only happen on like a broader level as part of an official community plan review or that sort of thing. So there's actually pretty much no opportunity right now for folks.
But we have
with
not
land
always
seeking
followed
ALR.
that policy. We've gone outside of that policy.
Yeah.
So anyway, sorry, continue.
Yeah. So I mean, that's what the messaging that I give to applicants as that's the board's direction. So there's that on the exclusions part. But in terms of the second dwellings, I think it might be helpful for you folks to review one document and sort of process that the RDCK recently did, which was on the agricultural policy review, which kind of looked at the changes regarding second dwellings in the agricultural land reserve and whether or not communities A, B, and C wanted to actually integrate that and allow that. And I think the answer was no for most areas. And then the third thing is just the general change where there is going to be the allowance for a second dwelling, whether that be detached or attached, which is coming down the pipe and how we consider that as part of our review process. So I think those are really good questions and they are definitely within the purview of the commission. So maybe it's just sort of doing a little bit of behind the scenes talking with Gary to figure out what the best way to present that information would be.
And maybe
cool
for
with you
March, would you maybe be ready for March? Yeah.
I think so. I think we can look at that.
Good.
We're ready. We can be ready, yeah.
Okay, so the next meeting is scheduled at Great Creek Hall, March 7th, 2024, 1 o'clock PST, 2 p.m. Mountain Time over here. And from here, I adjourn the meeting.
I second it. Do I have to do that?
Yeah. Okay.
Thank you, gentlemen.
Oh, sorry, checking. Daylight saving time is a couple days later, so we're good on the 7th. Perfect. I just wanted to double check.
Yeah, good.
Thank you.
George